Well, hello everyone, and welcome to this session. Employment law is what we're here to talk about. My name, of course, you know me, Lior Samfiru. That's me. I'm one of the founding partners of Samfiru Tumarkin LLP. We operate in Ontario, in BC, and Alberta. And I want to start off, first of all, by saying Happy New Year to everyone. This is my first time being here live this year, and looking forward to interacting with you, to answering questions, to solving as many workplace problems as possible on this session and every week and during sessions and on radio and on TV. I'm easy to find. But right now, I am here live. I'm here live to take your questions, to answer your questions about employment law. Again, I'm the employment lawyer, Lior Samfiru, with Samfiru Tumarkin LLP. And if you're in Alberta, if you're in BC, if you're in Ontario, and you have questions about your legal rights in the workplace, man, this is a great opportunity you have to ask that question. Sometimes things are great at work, but sometimes they're not. Sometimes you have questions about your job status, your responsibilities being changed. Maybe you're being mistreated. Maybe you think you're going to be let go, or maybe you have been let go. Whatever the issue, whatever the question, the problem you're facing, I'm here live to help you, to tell you what you need to know. We have excellent employment law rights across Canada. Most people don't know what those rights are. Well, I do. So I'm going to share that with you on this session, and I love taking your questions. I have plenty of stuff I can talk to even between your questions, but what makes it better for me, for everyone watching, is if you ask your questions. Now, before we get started today, let me give you some other contact information. If you want to learn more about your employment law rights, or if you want to connect with me and my team off air, very easy to do that. You just have to go to employmentlawyer.ca. Again, you see that address below, employmentlawyer.ca, and everything you need is there. You have my email address there, my phone number is there, a lot of other information, articles, and tools to deal with employment law. It's all there. So that's your one-stop shop, if you will, for employment law. It's employmentlawyer.ca. But that's after. Right now, I'm live. Questions are coming in. Ask your questions. Please don't do like a lot of people do, which is wait till the end of the session. If you wait till the end of the session, I may not be able to get it on time, and then you may not get your question answered. So ask your question right now while I'm live. You have plenty of time. Type it in, press enter. I'll see it. I'll read it. I'll answer it. But right now, I'm going to start answering questions. Welcome again to this employment law session with me, Lior Samfiru. All right, guys. First question from Greg on YouTube. The BC labor standards, Sam, owed 3 weeks severance. Well, the severance calculator say I should get 3 months. Why so different? So yes, first of all, before we even answer that, Greg mentioned severance calculator. My firm created a severance calculator that allows everyone to find out how much severance they're owed if they lose their job. And you can find it, by the way, by going to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You see that address right there. You see our severance calculator, which is free and anonymous. And whether you lost your job or worried about losing your job, maybe you're just curious, you want to know how much severance you're owed, that's the place to go to, pocketemploymentlawyer.ca. Now, so Greg says he used a severance calculator. It says he's owed 3 months, but the ministry, the BC labor standards says 3 weeks. Why that difference? Well, employment standards only outlines your minimum entitlements, not your full entitlements. So frankly, it's irrelevant. I don't really care, nor should you, what your minimum entitlements are. You care what your full entitlements are, what the full amount that the law says you should have. That's what the severance calculator calculates. It uses thousands of cases and court decisions to come up with that range that we have there. So that's why that difference. Your minimum entitlements can be 8 weeks. Your full legal entitlements could be 24 months. There's a massive difference. So please do the right thing. If you lose your job, you call me. You go to the severance calculator at pocketemploymentlawyer.ca. That's what you do. Government can't help you, and government can't even tell you what you're owed because, again, they're only enforcing minimum entitlements, not full entitlements. Very, very important question. So thank you for that, Greg. Excellent question. Lots of questions coming, so please ask yours as well. All right, next question today from N. Stinson. N. Stinson is a regular viewer here, so thank you for joining us. Happy New Year. N. Stinson asks, are difficult relations between employee and new manager or director sufficient for employee to claim constructive dismissal? Well, the devil's in the details, right? So what I mean by that is, well, what does difficult relations mean? Does that mean that they don't say hi in the morning and they just get to work? Or does it mean that the manager is abusing, mistreating, harassing, bullying the employee? Obviously, if the employee is being mistreated, bullied, spoken inappropriately to, that absolutely can be constructive dismissal. That's workplace harassment, right? So if it rises to that level, that bad relationship, that it's workplace harassment, it can easily be constructive dismissal, depending on the circumstances. It can also be a human rights violation. So absolutely. But again, I don't know necessarily what you mean by difficult relationship. I mean, your definition of difficult may be different than mine. What we're looking for is a form of mistreatment. And yeah, that can absolutely be a constructive dismissal. And for those that don't know what constructive dismissal means, it's a situation that because of what happened in the workplace, it allows the employee to consider their employment as being terminated and require their employer to pay them their full severance. Okay, so that's what a constructive dismissal is. So thank you for that question, Ed Stinson. You guys hopefully see how easy it is. You can ask your question right now. I'm getting through them. I'm going to answer your question. For those that just joined us, welcome. My name is Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I am here live answering your questions. All right. Next question. Tanya on YouTube asks, how do you handle harassment by management due to veteran disability status? So if you're being harassed because of your disability status, that's not just harassment, which is bad enough. That's a human rights violation. You cannot be mistreated, put down, discriminated against because you have a disability. So the first thing I would ask is there someone in the workplace that you can speak to? A more senior manager, HR, owner, someone that you can tell in writing that this is what's happening. And the reason I say that is if you do that, the company is under a legal obligation to deal with it, to investigate and to remedy that issue. So that is always going to be your first recourse if it's possible. Now, in some situations, you've tried to do that and nothing has happened. It didn't work. Or maybe there's really no one to talk to. Well, in that situation, then we need to consider constructive dismissal. We need to consider human rights legal action. That's when you call me, okay? And we can potentially get you out of there. We can potentially, if you want, scare off the company enough that they'll just treat you properly. We can also pursue human rights damages. So there's a lot of things you can do legally. But if it's possible, Tanya, I'd like for you to see if you can deal with the company directly to try to resolve this. Okay, hopefully that makes sense. All right, next question. I don't have a name. It just says from LinkedIn user. The question becomes, or the question is, my severance settlement is 2 months late. What are my options? My lawyer was Jonathan Margolin. However, he's no longer with the firm, and I'm not sure what my next steps are. It's extremely easy, extremely easy. You call me or email me. I'll take care of it. Okay, go to employmentlawyer.ca. Again, employmentlawyer.ca. We'll take care of it completely. That's all you need to do. Problem solved. Okay, thank you for that. All right, lots of questions today, guys. It's going to be a good session. Ask yours. You see a lot of questions are coming. I can already see we're going to have a backlog at the end, so don't wait till the end. Ask your question right now. If it deals with employment law, you're in the right place. All right, let's see. From Julio on YouTube. Is retaliation and wrongful dismissal the same thing? Wrongful dismissal is the action committed and came from the retaliation against the employee. So no, they're separate things. They're both wrong. So retaliation may be if you're let go because for an inappropriate reason. So for example, if you're complaining, let's say, about you're not getting paid overtime, you're complaining about workplace harassment, complaining about discrimination, and you're let go because of that, that could be considered retaliation. The legal term we use is reprisal. So you cannot be punished essentially for standing up for your rights. Okay, so that's one issue. Wrongful dismissal is a situation when you've been let go and you haven't been paid the severance that you're owed. 90% of people, 90%, and it's probably even more than 90%, frankly, when they've been let go, they've actually been wrongfully dismissed. Why? Because 90% of people, when they're let go, they're not offered the full severance that they're owed. Maybe they've been offered 6 months and it should have been 10. Maybe then have been offered 10 and it should have been 15. So in most cases, it doesn't matter if you're young or old, that you work for a company for many years or not, or big company or small company. In over 90% of cases, when you've been let go, that's actually a wrongful dismissal. But reprisal makes it that much worse if you've been let go because you stood up for your rights. So Julio or anyone else, if you feel, first of all, if you've been let go, you always contact me. But if it's actually you think you've been punished because you stood up for your rights, you call me even faster. Okay, very important to remember that. And to reach me, to reach my team, I've said contact me a number of times. Again, a reminder, here's how you do it. All you do is you go to employmentlawyer.ca. You see that right over here, employmentlawyer.ca. Phone number is there, email address is there, all the ways to contact me are right there. If you want to fill out a form, it's there as well. So take advantage of that. Great questions today. Love this. Next question comes to us on YouTube from Katerina. Okay. So Katerina was that LinkedIn user we had before about the severance being 2 months late. So Katerina, you contact me. Easy, problem resolved. You contact me through employmentlawyer.ca. Okay. Let's see. Next question from Glendon on YouTube. Recently, I had no pay for 2 weeks, 1 pay period, and 7 days without work. In BC, if you are not employed for 7 consecutive days, then you can collect TI. Am I being laid off or constructively dismissed? So yeah, if you're, it's a very simple arrangement, right, between employee and employer. You go to work, they give you work and pay you. Simple as that. If they don't do that, if they don't give you work or they don't pay you, the law considers that to be a termination, constructive dismissal. Even if the company has not said we're letting you go, the law would consider that to be a constructive dismissal. So yes, Glendon, you can choose to treat this situation as a constructive dismissal. You don't have to, I guess. You can wait around and see what happens. Absolutely your decision. But what you can also do is to say, no, that's not acceptable. You didn't pay me as you were supposed to. You're not giving me work. Enough is enough. I want my severance and I'm going to move on to a different job. If that's what you decide to do, Glendon, if you're saying, no, I'm not accepting this, I want to pursue constructive dismissal, get paid and move on, you call me. Okay, you contact me through employmentlawyer.ca and we go from there. Very important question. Sometimes, by the way, your employer may not flat out let you go. They may not just give you a letter saying they're letting you go, but through their actions, it may be the same thing. They don't give you enough hours. They don't schedule you. They reduce your pay. They demote you. All those things are things that the law considers to be a constructive dismissal. So you're owed severance. You can look at it as a termination if you want, even though the company is not directly terminating your employment. It's a decision that you can make as the employee. All right. So the next question on YouTube from Gene Smith. My employer has been stripping my duties away from me, and now they want me to move to a lower position. I don't want to be moved down. I've worked hard to get my title. What should I do? Well, so there's really only 2 options here. Well, there's 3 options. Option number 1 is you can accept what they're doing. Option number 2 is you can see if you can get it resolved with the company. Option number 3 is you can consider that to be a constructive dismissal. So they don't have a right to do what they're doing, but there's no way to physically stop them. You can't physically restrain them. Therefore, if they're doing it anyway, not allowed to, you can treat this demotion as a constructive dismissal. We've been talking about that throughout the segment, meaning you say, no, I'm not accepting this. This is not okay with me. So if you're going to make me, okay, I'm going to consider that as a termination. I'm going to make you pay me my full severance, and then I'm going to move on. Now, Gene, depending on how long you've worked there, you could be owed as much as 2 years pay, 2 years severance. So for Gene and for anyone else, again, one more reminder here. How do you find out how much severance you're owed? Very easy to do. You grab your smartphone, you grab your tablet, desktop, whatever you want, and you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. And you use our severance calculator tool. The first thing you see when you go to pocketemploymentlawyer.ca is you'll see that link for the severance calculator. That address is right there below. When you go to that severance calculator, it's going to ask you 3 questions. how old you are, the length of your employment, and the type of job. You just pick it from a drop-down menu, and then you're done. It's going to tell you how many months severance you are owed. You can even calculate that in dollars if you want, okay? It's free. It's easy to use. It's completely anonymous. You don't have to put in your name, the company's name. You don't have to put in your email address, nothing. It's all there just for your benefit. And as an additional thing, if you want to, and only if you want to, you can contact me directly from the severance calculator, okay? So pocketemploymentlawyer.ca. All right, let's see. From Monique, next question on YouTube. I recently took a sick day and my employer has said I need a doctor's note. Can they require this for a sick day in Alberta? Yes, they can do that. They can require a doctor's note, so there's nothing wrong with that. It may be petty to do, but they can require it. All right, let's see. Next question. By the way, guys, still have plenty of time, so ask your question. It's okay to listen and learn, very important. But if you have a question, if you're struggling with an issue, why not ask the question? Why not give me the opportunity to help you, to educate you, to tell you what to do? Okay, so ask your question right now. You see the box on your screen. Ask your question, press enter, and I'll see it. All right, Tanya has a follow-up question. I applied for reasonable accommodation and was told I had to use vacation leave, sick leave, or I'm not sure what you're saying there, for hours unable to do certain jobs. Is that reasonable accommodation? Well, I don't know exactly what the accommodation is that you needed, right? So if the accommodation is that you need light duties, well, using your vacation time doesn't answer that. If the accommodation is that you need to be allowed to go to a doctor's appointment, then that may be, right? So without knowing what the accommodation that you need, I can't tell you if that is reasonable. Ultimately, to get accommodation, you need a doctor's note that says, here's the accommodation that you need. Modified duties or modified hours, or maybe to work from home, etc. Then in that situation, yeah, in that situation, you're owed, or the employer has to comply with what your doctor says. Tanya says that she was asked for a leave without pay. So again, you're still not telling me what the accommodation is. If you could do the job just with help, then they have to make that happen. But if your employer says you need to be off work, then it's okay. They can say to use vacation time, and after that, it becomes unpaid. So the question is, what was the accommodation that your doctor says you needed? All right. Next question is from Archie on YouTube. I've been allowed to work from home for the past 5 years. My employer is now recalling everyone to the office and have included me in this. Can they do this? I wasn't in the office before. No, they cannot. But the fact that they cannot doesn't necessarily mean that you can stop them. Here's what I mean. So if they recall you back to work and they don't back off, then here's what happened. Well, let me take a step back. If they don't recall you back to work, here's what you can do. Obviously, you can accept it and go back if you want. That's fine. You can say, no, I'm not doing that. If you say I'm not doing that, what could happen? Either they back off and say, fine, we'll leave you alone and you can work from home, or they'll terminate your employment, but they have to pay you severance. Now, the company may say, oh, because you're not coming back, we're going to consider that as a resignation. No, wrong. That would be illegal. That would be what we call a without cause termination, and they have to pay you severance. Remember, an employer can let you go for most reasons as long as they pay you severance. So yes, they can let you go, Archie, for not coming into the office, because they can let you go for any reason, but they would have to pay you your full severance. But it's quite possible that if you tell them, I'm not coming in, sorry, I've always worked from home, I'm going to continue working from home, that they'll back off. But if they don't back off and they let you go, call me right away, because they will likely consider that to be, or say that it is a resignation. It's not a resignation. You're going to be owed your full severance. And if you were there for 5 years, you could easily be looking at 8, even 10 months of severance. Okay, that's a lot of money. So now you know, Archie, and you know what to do. If that happens for you, for anyone else, you need to contact me, employmentlawyer.ca. Again, employmentlawyer.ca. Okay, and Archie has a follow-up here, says that I have a disability that limits my mobility. This is why I work from home. Well, here's then what you do. You give them a doctor's note. You may have given them a doctor's note before. Give them another doctor's note saying, for medical reasons, you need to work from home. Because at that point, if they don't allow you, not only is it something that they owe you severance, it also becomes a human rights violation. Okay, it's even more illegal. But something tells me if you were to give them a doctor's note that makes it clear that you need to work from home, they'll back off. Okay, but get that doctor's note. You may have said, I don't need to because I gave it to them 5 years ago. Forget about that. Do it now. Give them a doctor's note. And if they don't comply with it, call me. Okay, I may be able to give them a kick in the pants that makes them back right off. Okay, get that doctor's note. Very important. Guys, you see how easy it is? I'm going to answer another question in a second. We have 10 more minutes or so, but ask your questions. I always see questions on the screen after I've already ended the session. Don't let that happen to you. You have time right now to get your question answered, to even ask a follow-up question if you want. Take advantage. And of course, if you want to reach out to me off air, I've given you that address. I'll give it to you one more time now. employmentlawyer.ca. Employmentlawyer.ca is the way to reach me and my team off air, by phone, by email, through a form. It's all there. All right, let's see. Next question comes from Renata. My husband has been dealing with heart problems and I had to take a medical leave for this. He is still on leave and recently received a note from his employer that his position has been restructured. Can they do this? So, well, they can, in the sense that they are allowed to run their business. But if they've already told them, we already know we don't have a job for you anymore, well, wait a second. How can they say that now? Because your husband is not yet going back to work. So it may be true that today they don't have a job for him. But if your husband, let's say, is not coming back for 3 months, maybe at that point they do have a desperate need for him. So it's very premature for them to say, we already know now that we don't have a job for you, so don't bother coming back. So that could potentially be a human rights violation. Certainly, at a minimum, your husband is owed severance. But if they've already told them there's no job for you, that could be a human rights violation as well. You need to call me, or your husband needs to call me. Your severance, or his severance, I should say, is going to be even higher because he has a health condition that impacts his ability to work. So that means whatever severance he normally would have gotten is going to have to be even more now to account for the fact that it's going to take him that much longer to find a job because, again, he's still struggling with his health. So they should not have done what they did because your husband is not ready to go back to work. So Renata, have your husband contact me, okay, as soon as possible, and I'll connect with him and I will make sure that he's treated properly. Great question. You know, certainly always very difficult to be off on a sick leave and be told you don't have a job anymore. Not the way an employer should do that. What the employer should do instead is, when you're ready to come back to work, at that point, they have to take a look and say, okay, do we have a job? Let's make every effort to bring the person back. And if they looked, if they've tried, and if there really isn't, then and only then can they terminate employment, of course, with severance. They can't say that, well, we don't know when you're coming back, but we already know. We're clairvoyant. We know we don't have a job for you in the future. Can't do that. Same, by the way, with the parental leave. So let's say you're a mother or a father on parental leave. You're still going to be off leave for a few months, and your employer contacts you and says, oh, by the way, we don't have a job for you anymore. Well, wait a second. How do you know? Okay, so that's illegal to do it that way. So keep that in mind. And if that ever happens to you, if it sounds familiar, call me, okay? employmentlawyer.ca to do that. All right, but right now I'm still live. I'm going to answer questions, ask your questions as well, okay? Let's make sure that when you turn off your computer, you have more knowledge about your rights than you did coming in. Ron has the next question on YouTube. What can I do when a member of the senior management team is the one harassing me? It's actually my wife I'm asking on behalf. Well, that's a great question, because if it's senior management, then who are you going to complain to? Because there's really no one above them. So if you can't, or if your wife can't deal with the issue internally, then we have to deal with it externally. What I mean by that, that's where I come in. Myself, my team, she needs to call me. And if she's being harassed and bullied, then we can show that that's the case and there's no option to deal with it internally. Now it's time to say, enough. Let's get her out of there so she doesn't suffer, so she doesn't have to deal with that type of treatment. It's a constructive dismissal, can also be a human rights violation. So the preference is always to deal with it internally, to give the company the opportunity to fix the problem. But if that's not possible, because it's senior management. Who else is going to deal with it? Senior management harassing. Then we need to get involved and get her out of there. The key, though, Ron, is going to be to prove that harassment. Keep in mind, the person that's harassing her is not going to admit it. They're not going to hang their head in shame and say, yes, I did it, right? So we always want to think, how do we prove it? Do we have witnesses? Do we have something in writing? Do we have a recording? How do we establish that harassment? But if we have that proof, very, very easy to pursue this. And even if we don't have the proof, I can talk to your wife about how do we build that proof? How do we create it? How do we get it? So very important one to have your wife call me and let's discuss. Okay. So N. Stinson has a follow-up question. She says, any chance of devoting an entire future episode of Employment Law Show to work from home questions? That one issue impacts many people. I love that idea. That is a brilliant idea. So I promise you, in the next few weeks, I will do a radio show just dedicated to that. And we'll try to let you guys know through social media when that happens, probably in the next 2 or 3 weeks. I think that's a great idea. So many people now are working from home. I'm actually embarrassed that I hadn't thought about that myself. So many people now, certainly over the past 3 years, are working from home. There's tons of questions about that. Employee rights, employer rights. Can the employer do this? Can they not? So yes, I am absolutely going to do a session about that. I should have thought of that myself. So thank you very much for that instance, and I appreciate that. And stay tuned. Okay, let's see. Next question. Tanya has a follow-up question. Can't speak. The accommodation was for just the first hour of my shift, where everyone has to work together, which being in a large group bothers me. Therefore, I have to take a leave at the beginning of the shift. So yeah, I mean, if the accommodation is that maybe you start later or your hours change a bit, then yes, they have to provide that accommodation. They can't say, well, because you need to be doing something different for an hour, you're gone, you have to use vacation. No, that's excessive. That's not reasonable accommodation. So if you have a doctor's note, so number one, make sure you have a doctor's note that says, here's what you need. That's very clear. The doctor's note needs to say, yes, you absolutely can work, but you just need this minor accommodation. Make sure you give them that doctor's note. If you haven't, get it. If you have, okay, call me right away and let me see if I can help you. And of course I can. But if you haven't gotten the doctor's note, give that doctor's note. If nothing changes, again, you call me and let's deal with it. So hopefully that makes a lot of sense here. All right, let's see here. By the way, hey, Lior Samfiru, that's me, the employment lawyer. Let's answer another question from Shireen on Twitter. My employer has said that I am considered a contract worker and not entitled to any severance. They will not be renewing my contract at the end of the month. Is this true? Well, obviously, I don't know anything about your work. Do you work just for them? How many hours? Do you work regularly in the office? Do you work from home? How do they pay you, etc.? I haven't seen the actual contract, but here's what I'm going to tell you, Shireen. In the vast majority of these cases, people that they're told they're contractors, in fact, they've been misclassified, and they're really, in the eyes of the law, employees, which means, yes, you're going to be owed severance. So yes, the devil's in the details. I want to know much more about your job, about the company, etc. And of course, I want to see that contract. But chances are, if I'm sitting here a betting man, I'm absolutely betting on you being owed severance. Okay, very good. So call me. So guys, I think I'm caught up here with questions, and great session today. Lots and lots of questions. I love that. That's what I want to do, answer as many questions as possible. Now, just FYI, tomorrow, January 12th, happens to be my birthday, but don't worry about that. January 12th, tomorrow, my colleague, Sandy Chan, will be talking about disability and employment law. Here, he's going to be doing that at 1 p.m. Eastern, 10 a.m. Pacific. So stay tuned for that. I'll be back next week, but don't wait till next week. If you have a question for me, or if you need help from me, you can connect with me today if you want. Send an email, make a phone call. You can get all that information at employmentlawyer.ca. Don't wait until next week when I'm back here. Do that today, okay? Again, Happy New Year, guys. Great way to start the year. I'm always feeling privileged to have this opportunity to speak to you. So thank you for giving me that time. Hopefully I've answered questions. Go to employmentlawyer.ca, and I will see you again soon. Thank you, guys. Take care.